You're sitting in the back of a patrol car on the side of a road in Northwest Indiana. Your hands are behind your back. The officer is outside writing something down, and you just got arrested for an OWI, operating a vehicle while intoxicated, in the state of Indiana. And you have absolutely no idea what is going to happen next. Here's what most people in that moment do not know: the next 48 hours will set the tone for your entire case, not your court date months from now. Right now, the decisions that you make tonight and how quickly you get an attorney involved will matter more than almost anything that comes afterwards. And the decisions are already stacking up that most people do not even know about. Nobody explains them at the jail. Your friends and family probably do not know them either. And some involve your driver's license privileges. Others involve evidence for your defense that starts disappearing within days. Waiting to deal with them does not just cost you convenience, it closes off good defenses that you would have had. We will get there. But let's first walk through exactly what the next 24 to 48 hours will look like, because knowing what is coming is the first thing that helps you stop panicking and starts thinking clearly. The booking process in itself is straightforward, but it's not fast. After the arrest, you will probably be transported to the county jail. And in Lake County, that means the Lake County Jail in Crown Point. They will photograph, fingerprint, collect your personal belongings, and run you through their intake system. Depending on how busy the jail is, that process can take anywhere from 2 hours to most of the night. You are not going anywhere quickly. And that is true even if your family is calling around trying to get you out. The system moves at its own pace, and nobody speeds it up just because you are anxious or this is your first time. During intake, your vehicle will either be towed or, in some situation, it is released to a licensed passenger who was in the vehicle with you. Click clear on what is going to happen to your car before you walk out that building. Towing and impound fees can add up quickly, and retrieving your car is an additional step that catches people off guard when they're already overwhelmed. While you are in that room, stay quiet. I cannot stress this enough. I have spent years as a prosecutor in Lake County and have seen cases that were otherwise defensible get seriously damaged by what a defendant said during booking or in a casual conversation with another person sitting in a holding cell. Beyond providing basic identifying and booking information, you should not discuss the facts of your case and clearly evoke your right to speak with an attorney. Officers are trained to build rapport with you. The conversation that feels like small talk is not small talk. It is potential evidence. Say nothing about what you drink, how many drinks you had, where you were, how you were feeling, what speed you were going, whether you knew the checkpoint was coming ahead. Nothing. If you are asked anything beyond identifying information, the answer is, I would like to speak with my attorney. Say it once and stop talking. The breathalyzer question has probably already come up by the time you are sitting in that patrol car. Indiana is an implied consent state, which means that when you apply for your Indiana driver's license, you legally agreed to submit to a chemical test if you had a law enforcement officer had probable cause to believe you were operating a vehicle while intoxicated. Now, you can refuse that agreement. If you refuse to do the chemical breath test or a blood draw, the officer would have to note that as a refusal. And a refusal does not mean your case goes away. If you refuse a chemical breath test, the state may not have a certified chemical breath test, but prosecutors can still rely on officers' observation, field sobriety tests, body cam footage, witness testimony, and other circumstantial evidence. A refusal is not an automatic conviction, but it is not a shield either. A refusal can carry its own consequences for your driving privileges on top of whatever happens in your criminal case. If you took the test and it came back at a above 08, that reading is evidence, but it's not necessarily the end of the story. Breathalyzer results depend on the accuracy and calibration of the device, the procedure followed by the officer, the timing of the test relative to when you are actually driving, a handful of physiological factors. Those are all things a defense attorney will examine. After booking, many first offense OWI arrests in Indiana result in release on your own recognizance or a modest bond. Although that depends on the factors of your case, the county, and the person's criminal history. Unless there are aggravating factors, most people are not sitting in the county jail for weeks or months. You will be given paperwork when you leave, including a court date and information about your charges. Read every piece of that paperwork before you leave, or sit down with someone who can help you understand. Do not stuff it in your pocket and figure it out later. Your release also comes with conditions, typically including things like no operating a vehicle while intoxicated. Sometimes no alcohol consumption at all, depending on the court and your pretrial release services. A mandatory appearance at all of your hearings. Violating those conditions before your case is resolved can dramatically change your situation and not in your favor. Now, here is a mistake I most want you to avoid: waiting too long to speak with an attorney. While Indiana does not have the same BMV hearing process that some other states use, important decisions affect your driving privileges can begin almost immediately. At your initial hearing, the court may determine that there was probable cause for the arrest and recommend an immediate suspension of your driving privileges, or in some cases, recommend the use of an ignition interlock. Those early decisions can significantly affect your ability to drive while your criminal case is pending, and the license consequences that can follow a conviction are a separate matter on top of that. We cover how first offense and felony OWI penalties stack in a different video if you need that breakdown. The first 24 to 48 hours are also critical because evidence needs to be preserved. Body cam footage, dash cam video, surveillance footage, witness statements, and chemical testing records can all become important later in your defense. The sooner an attorney becomes involved, the sooner they can begin evaluating whether to stop, the arrest, the field sobriety test, and the chemical test comply with Indiana law. Calling an attorney within the first 24 to 48 hours of an arrest is just not about emotional support. It is about getting someone working on your side while the evidence still exists and before the early decisions get made without you. Your first court appearance in most northern Indiana counties will be an initial hearing or an arraignment. This is where formal charges are read and you enter an initial plea. In most cases, you do not want to walk into that hearing without legal representation. Entering a plea without understanding the full evidence picture, the charging document, and your range of options is one of the more common mistakes I see in the early stages. If you do not have an attorney yet, you can ask the court for a continuance. Many courts will grant a short continuance to allow you to hire an attorney, although that decision is always within the judge's discretion. That brief extension can give you time to get proper representation in place. What you do in the first 48 hours after an OWI arrest in Indiana matters more than most people realize. The license decisions that can begin at your initial hearing, the decisions about what to say and what not to say, the evidence that needs to be preserved before it disappears. All of those things starts happening before most people have had a single conversation with a lawyer. Understanding the timeline is your best tool for not making it worse before you have a chance to make it better. One more thing before you move. Write down everything you remember right now while it is fresh. The stop itself, the questions the officers asked, the field sobriety test, the instructions that you were given, the timeline of the evening, the road conditions, how many officers were present, and what was said and when. Memory degrades faster than most people expect. Every detail you capture now is something your attorney can work with later. The things that you think that are irrelevant are often exactly what end up mattering. If you have found this video helpful, the next video covers Indiana OWI penalties in detail, including the factors that escalate a first offense misdemeanor into a felony charge. Some of those triggers are not what people expect, and knowing them changes how you look at your own case. If you are dealing with an OWI arrest right now and need to talk through your specific situation, contact information for Justin Camper Law is in the description below. What is one thing you wish you would have known right after an OWI arrest, whether it was yours or someone you know? Drop it in the comments below. Someone reading this right now needs to hear it.